On February 1st, 2010, Pacific Legal Foundation responded to 12 complaints filed by the National Women's Law Center. The complaints were originally filed with each regional office of the Office of Civil Rights. PLF requested a conference with each office to discuss the problems with these complaints. Why is PLF sending these letters to the offices of civil rights?
Well, on November 10th, the National Women's Law Center sent 12 administrative complaints alleging that 12 school districts throughout the country are discriminating against girls in high school sports.
Why does the National Women's Law Center think these school districts are discriminating?
Well, the National Women's Law Center bases its complaints entirely on proportionality. In other words, what the complaints say is that there are, for example, 60% of the student body is girls, but only 55% or 40% of girls are participating in sports. Therefore, because of this disproportions, they say that that means discrimination.
Well, what do you mean by right proportions?
Well, in 1979, the Department of Health and Education and Welfare established what they termed a three-part test for intercollegiate athletics. And what this three-part test does, at least part one of the test, says that if a school district isn't, or if a college, because it's intercollegiate athletics, isn't providing athletic opportunities to girls in the same proportion that it is that they are enrolled at the college, then that necessarily means, or at least it gives an inference of discrimination at that college.
What does the three-part test say about proportions?
Well, what it says about proportions at high schools is absolutely nothing. In fact, the three-part test is titled a policy interpretation, the three-part test, and intercollegiate athletics. Because it has nothing to do with high school athletics and proportions at high schools, we believe that the National Women's Law Center complaints lack any legal basis.
Does PLF have any other legal concerns?
Well, not only does the three-part test application to high schools lack any basis in the law, but it also raises serious constitutional concerns because the Department of Education has no evidence that there is discrimination occurring at grand scales at the high school level. So if they apply the three-part test to high schools, that would mean they're doing it without a sufficiently structured evidentiary basis on which to institute these sex-conscious programs. Therefore, because they're treating people differently based on their sex, we feel that that could raise serious constitutional concerns under the Equal Protection Clause.
What does PLF hope to accomplish with its letters?
Well, I think we hope to accomplish two things. First, we hope that the Office of Civil Rights will take our concerns, our legal concerns, seriously and realize that the National Women's Law Center's complaints lack any legal basis and raise these serious constitutional concerns under the Equal Protection Clause. Secondly, we hope to arouse public opinion and people will stand up and realize what the National Women's Law Center is doing here has the potential of wreaking havoc in our school districts throughout the country and providing less opportunity for both boys and girls in high school sports.